So good day. We are Group 6 of 3 and 4 composing of Rorsena, Gamilla, Lim, and Mercado. Today we will discuss the case between First Optima Realty Corporation and Securitron Security Services Incorporated that occurred last January 28, 2015 with GR number 199-648.
So, First Optima Realty Corporation, the petitioner, domestic corporation engaged in the real estate business, registered owner of 256 square meter parcel of land with improvements located in Pasay City, represented by Vice President Ms. Young. And then for the Securiton Security Services Incorporated, the respondents, domestics corporation with offices located beside the subject property and represented by General Manager Antonio Eliazar. Next.
On December 9, 2004, the general manager of the respondent named Antonio Elizar sent a letter to the petitioner through its executive vice president, Carolina Tiang, offering to purchase the subject property at 6,000 pesos per square meter. However, there was no communication occurred between the two. Instead, it was between Elizar and Maria Remoso, the secretary of the petitioner. Eleazar went to the office of the petitioner, offering to pay the subject property in cash, which was declined by Young since prior approval from her sister and the board of directors is required for the transaction to occur. Thus, Eleazar shall have to wait for approval. On February 4, 2005, the respondent sent a letter to the petitioner which includes a Philippine National Bank check number 24677 amounting 100,000 pesos as payment. The said letter was not directly delivered to Young or her office, but rather received by a receptionist of the petitioner who issued a signed provisional receipt number 33430. The receipt contains confirmation of received 100,000 pesos from Antonio Elizar as partial payment for the Pasay property with a note, this is issued transactions not yet cleared, but subsequently an official receipt will be issued. March 3, 2006, the check was then credited to the petitioner's bank account. Then the respondent through counsel demanded a proceed with the property sale of the petitioner, which she responded via a letter last March 3, 2006. The letter states that Securiton Security Services via Mr. Elizar offered to buy property in Pasay City. They were undecided to sell the said property despite the payment being considered as earnest money. The board of directors has not yet decided to sell the property with your client. There was no contract of earnest money nor the contract to sell the property. Lastly, the respondent declined the petitioner's offer to buy the property due to their actions being considered to be haste and are form of intimidation and harassment. The petitioner is advised to coordinate First Optima Realty Corporation for the refund of the money.
April 18, 2006, the respondent filed a civil case against the petitioner for specific performance with damages on April 18, 2006 at Pasay Regional Trial Court. The complaint is based upon the claim that a perfected contract of sale and accepted payment of 100,000 occurred between the parties. Thus, the petitioner is compelled to sell the property, fulfilling his obligation as a seller. As a consequence of its breach and delay in the performance of its obligations, petitioner be made to pay 200,000 pesos damages by way of attorney's fees and cost of suit. The petitioner's counterclaim argued that she never agreed to sell the property since the board of directors did not authorize the sale to the respondent and no resolution was issued. The payment of a 100,000 peso check can be considered as earnest money since it was only received by a clerk who was forced to accept. There was only the respondent's desire to purchase the subject property, which the petitioner prayed for the dismissal of the case. It sought the payment of moral damages in the amount of 200,000, exemplary damages in the amount of 100,000, and attorney's fees and costs of suit. In reply, the respondent stated that it was not necessary for a real estate corporation principally engaged in the buying and selling of the real property to need authorization from its board of directors. There was no force nor intimidation occurred towards the receiving clerk into accepting the letter and check, since the petitioner accepted the check and its failure to return the payments for more than a year to estoppel and ratification of the sale, and the petitioner is not entitled to its counterclaim.
The Pasay RTC issued a decision last February 16, 2009, stating that First Optima Realty Corporation must comply with its obligation as seller to Securitron Security Services Incorporated with a remaining balance of 1,536,099. According to the trial court, the petitioner's acceptance of 100,000 earnest money indicates the existence of a perfected contract of sale between the parties. There was also no evidence of force and harassment during the occurrence of February 4, 2005. And lastly, Young was free to represent the corporation in negotiating with the respondent for the sale thereof, even without the resolution from the board of directors.
So the petitioner filed an appeal with the Court of Appeals against the ruling of the RTC that the possible sale only occurred, not the sale itself, in the absence of written authorization from BOD. Young cannot enter into the sale for its corporate property. Lastly, that there was no meeting of the minds between the parties in the first place. And on September 30, 2011, the CA reiterated Article 1B18, affirming the trials court February 16, 2009 decisions. And there was indeed a negotiation between the two parties regarding the sale. However, this agreement lies under their place. The CA affirms the finding of the trial court sided with the plaintiff appeal, since the letter dated February 4, 2005 reiterated their agreement of sale was not disputed nor replied by the petitioner. Number two, if the defendant appellant didn't really agree to the sale, it should have responded that there would be no selling to occur. Number three, the acceptance of money and issuance of the receipt shows that there was indeed an agreement between the parties, and the accused force and harassment was the bond. And number four is it is hard to believe that the petitioner did not only is the earnest money that was deposited in their bank account. After 1 year, their inaction should have resulted in the clearing of unwanted tenants before the full amount of the purchase price will be paid as agreed upon. Article 1482 stipulates that but whenever earnest money is given a contract sale, it shall be considered as part of the price and proof of the perfection of the contract. Although the presumption is not conclusive, as the parties may treat the earnest money differently, there is not mention of the present case that implies the contrary presumption, which in this case is in the presence of payment and receipt. The COA stated that a corporation whose main business is buying and selling real estate is not required to have a corporate business. Thus, the petitioner claims resolution from the BOD was not received. The High Court reiterated that a corporate officer or agent may represent and bind the corporation in transaction with the third person to the extent that the authority to do so has been conferred. This includes power which have potentially conferred, and also such power as individual are incidental to or may imply from the powers potentially conferred. Powers are added by custom and usage as usual pertaining to the particular officer of the agent, and such apparent powers as the corporation has caused persons dealing with the officers or agents to believe that it was conferred. Ms. Young, the executive vice president, was authorized to negotiate for the possible sale and therefore can represent and bind the defendant's appeal in the trial. transaction. The respondents can assume that Ms. Young, being the vice president, was authorized to sell since this is not a foreign for such a position, and the sale was shown to be a normal business activity in real estate, falling with the scope of her general authority. The argument that a board resolution is indeed needed for the sale is a stop from racing since there was no clear communication for such regulation between the parties. And lastly, there is no reason to deviate from the trial court findings since the contract was entered freely, thus obligation must be performed faithfully. First Optima Realty Corporation unjustified refusal to perform its part of the agreement constitutes bad faith, and the court will not tolerate the same.
First Optima Realty Corporation moved for reconsideration on December 9, 2011, but the CA held its ground. The petitioner raised the following issues. The money delivered by the respondents was considered earnest money. The time lapse in returning the money was assumed to be acceptance of the earnest money. The Honorable Court upholds ignored the reservation of provisional receipt and note stating that note, this is issued to transactions not yet cleared, but subsequently an official receipt will be issued.
The petitioner seeks to reverse set aside the sale CA disposition since first, respondent failed to prove the perfected contract of sale between the parties since the circumstances that occurred did not all that prove that a contract of sale was perfected between the parties. The letter and check were not delivered directly to Ms. Young, and the receiving clerk of the petitioner only received the payment due to it, being part of the course in its day-to-day business and operational procedures. Second, this doesn't mean consent to any transaction while the respondent's letter and check are only considered to be an offer. Third, the petitioner believes that since there is no perfected agreement occurred, the check should not be treated as earnest money, but as a mere guarantee to prevent backing out of the sale.
The respondent argued that the petitioner's desire to escape the legal consequences reiterated her failure to reply to the February 4, 2005 letter. Acceptance and issuance of receipt confirms the agreement between the parties and perfection of the agreement due to the presence of earnest money.
The court grants the petition since important facts were overlooked that would change the complexion and outcome of the case. Since there were no negotiation between the parties declining to enter into an agreement and accept cash payments, Ms. Young informed Eleazar that she still needs to confirm her sisters and BOD, which Eleazar agreed to wait for the approval. When there is merely an offer by one party without acceptance of the other, there is no contract which the trial appellant or failed to acknowledge that accepted the purchase. The court stated that the parties never got past the negotiation stage since no evidence is presence of final arrangement satisfy a construct of sale, specifically consent or the meeting of the minds of the parties, object or subject matter, and price or consideration of the sale. The letter and check of the respondents last February 4, 2005 was only considered to be a reiteration of the original offer, which was rejected, thus the petitioner was not obligated to reply. Thus, the said letter cannot be considered as evidence of perfected sale and no binding obligation to sell the property. The latter did not make any new offer to replace the rejected one. Following the Article 1482, the absence of perfected sale means that the respondents have no obligation to make payment, possess earnest money to bind sales. The petitioner explanation was deemed acceptable since it was mixed up with other checks during the course of its daily operation, and Ms. Young's failure to return the purposed earnest money doesn't portray agreement of offer. The respondents' actions are irregular and extraordinary, while the respondents already knew from Eleazar's previous meeting with Young that it could only effectively deal with 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 her. More than that, it should know that the corporation work only through the proper channels, such as actions, place itself under grave suspicions of putting into effect a premeditated plan to unduly binding the petitioner to its rejected offer, resulting under the false pretense that an agreement was already arrived at, even thought there was none. Court sided with the petitioner, while the respondents cannot blame the petitioner for not, since it is equally blamed. Court cannot presume the existence of this sale since there is no direct proof to support it. So the petitioner is not required to perform the application to the respondent's civil case number 06049 CFM for specific performance with damages should be followed. And there is no need to resolve other specific issues and arguments by petitioner since there is no agreement between the parties and it would not affect the outcome of the case. The resolution of the Court appeals, the decisions of the Regional Trial Court and Branch 115 in civil case number 06049 CFM are reversed and set aside, and the petitioner must refund